Hey everybody, it is June 2019, and if you are watching this video, that can probably only mean one thing, which is you have made it through the long, hard slog of the PF season, and you are competing at NSDA Nationals.
God bless you.
Yes, God bless you all. Godspeed. Congratulations, though. It's a tremendous accomplishment. We are here to do what we always do at Hail State Debate, which is break down PF topics for you. I'm Brett Harvey. I'm the coach. We've got Josh McCoy, our ace varsity debater.
I'm back. I was gone for a while. I got a new job.
He's been busy. He's we'll call it a sabbatical, whatever. But we are back, and we're excited to talk about the topic in NSDA Nationals. Again, it's going to be super competitive, as it always is. And this year, it's going to be made even more complex by the topic. Resolve: the United States federal government should enforce antitrust regulations on technology giants. It's a lot.
That's a lot.
It's a lot to take in.
It's really complicated. There's a lot of background to it. There's a lot of different arguments you can make. Some of them aren't so good. There's a lot of stuff out there already about this topic that we're going to try to guide you around and show you the light. We're
going to try to demystify it. It is a complex topic with a lot of things going on. As always, we want to be helpful. If we are, maybe give us a like, maybe subscribe, maybe tell a friend. Your novice is coming in next year, maybe tell them. If you have questions, drop them in the comments. We love questions. And as always, we will have our sources and timestamps below in the notes. Maybe also check us out on Twitter at Hail State Debate. That can be helpful sometimes.
Yeah, that's where we're most responsive, because we'll get notifications immediately if you DM us or tweet at us.
That is true. So, maybe consider doing that. Without further ado, though, I guess maybe some preliminary thoughts on the topic. My thoughts are, like we said earlier, it's a lot. I mean, it is an incredibly complex topic. I'll say that if this were the topic we were starting the year with, if we were throwing novices into this, I would be really alarmed.
Yeah.
Call the NSDA alarmed. But we're doing this at Nationals with the best of the best, and you guys can handle it. But, there are a lot of variables here. Number one, antitrust is a notoriously complex area of the law in and of itself. Even lawyers who don't practice specifically antitrust, like me, right, for example.
There's a reason lawyers specialize in antitrust, because it's so complicated.
Right. It's heavily dependent on economic theory. It's a lot of high-flown abstract stuff. It's not easy to master. In addition to that, I will tell you frankly that the antitrust arguments, even among the sort of big four tech firms of, Google, Apple, Facebook, and Amazon, even within that very narrow group, the antitrust arguments that would actually apply to them vary greatly. So there's a lot to handle there. And then finally, this is a topic that's rapidly, I guess both, evolving. In the sense that tons of things have gone on since February with the creation of the FTC task force, the FTC DOJ memorandum of understanding, where they sort of split up jurisdiction. And now, just the other day, you have Congress saying they're going to have hearings on this. So you have multiple different theories in a complex area of the law where the facts are changing. And frankly, folks, this is just a lot.
And you're going to have to keep up with it every single day leading up to and during the tournament. It's wonderful to pull out cards that are according to Business Insider yesterday,
or no, according to Business Insider of 15 minutes ago. But it's a high skill ceiling topic. Between two bad teams, candidly, this could be a disaster. Between two very good teams, it could be amazing.
These are the kind of rounds that, during finals, people are going to be applauding and going absolutely nuts in the big stage for. So.
Especially the other PF debaters there who appreciate the complexity. Yeah. What do you think?
I think the biggest thing and the best way you're going to win, or the best way to hedge your bets for winning, is just to know about it. The easiest way, especially in Crossfire, to make your opponent, frankly, sound kind of dumb, is if you know a lot more about it, you know the background, and you can point out something that's logically incorrect or doesn't really make sense with how the real world works in antitrust laws.
There is so much depth on this topic you can learn. And on the one hand, that's intimidating. But on the other hand, at a tournament like this, the more you know, I'm sure we'll flash that graphic up there as we've done before, but the more you know, the more you have the opportunity to flank people, to sidestep arguments, to just seem smart for judges.
And the better you are at boiling things down to be really simple.
Yes.
The best way to make things simple is to know everything about it.
Yes. One of the ironies about debate is the people who are able to say things succinctly are often the ones who know the most, because they know what matters and they know what doesn't matter. But anyway, with that, we will move on. The roadmap is going to be, first, we're going to do a little short segment about debating at NSDA Nationals. For those of you who haven't been before, just a few ideas about how the tournament works. We'll then move on to framework and definitions, then pro arguments, then con arguments, and then finally we will wrap it up. A couple of things about this particular video. It could conceivably run a little long because it's a complex topic. We're not going to shortchange you because we know you guys are the ones who have worked the hardest to get here. So we're going to go into a little bit of depth. The other thing is the slides on this are going to have a lot of information on them. So what you might want to do is you might need to hit pause while we're talking and read over them, or you could just screen grab them if you want. We will try to put them up on Twitter to the extent we can. I hope we can, so that you can just have them. But there's a lot of information there, so you might need to slow down and look at those. But with that,
well, right, and as always, with everything we're putting, we're going to put links in the description
yes,
and stuff like that. We're going to make sure you're able to access everything we're telling you in this video.
All right, so we got we once more into the battlefield, folks. But we got a lot to cover, so let's do it. Let's get started with how to debate an NSDA right now. Okay, so first, let's talk about how you can do well at NSDA in terms of just general debating strategy. NSDA is an interesting and unique national circuit level tournament in the sense that it combines, I think, the rigor of the really advanced circuit-y style tournaments with the need to also accommodate many different kinds of judges and traditional judging styles.
Well, and you're going to see a ton of different cases. There's a good chance you could go 6 rounds and not see the same case.
Absolutely.
Because these guys are going to be thinking about it just as much as you are. They're going to put weeks, months worth of effort, weeks of effort into this. Yeah. There's going to be a lot of info, and you're going to need to be able to tackle all of it, but do it in a way that most judges or all judges can understand.
Right. So 4 quick points. First, let's talk a little bit about the logistics. Number 1, the great thing about NSDA is you know exactly what you have to do to advance. They've decided that they don't have a numeric cutoff. They have a record cutoff. At least they have in the past. I assume they're still doing this year. But you're going to have 6 rounds. You're going to have 12 judges. That means you're going to have 12 ballots. And you have to go 8 and 4 on those ballots to advance, right? So that's easy, and that's that's doable. 8 and 4. You have a couple of rounds where you win them both, and then the rest of them you can split. You can lose a couple, and you can be doing fine. The other thing to remember is, unlike pretty much all tournaments, all of your prelim rounds will be randomly paired, which means in theory you could literally hit the top 6 teams at the tournament.
But you could also hit the top or the bottom 6 teams.
Yeah, right. And statistically it will average out. But there is absolutely no point in trying to read the tea leaves about who you're hitting in prelims, because it is apparently just done by pulling it out of the sorting hat or a random number generator or something like that. I think there is some effort to keep people from the same geographic area apart, but it's very doable. You can go 8 and 4. It takes some preparation, but you can do it. Tip number 2 would be you're going to see a diverse array of judges. A lot of people, when they say getting ready for NSDA or NCFL, say, oh, you need to prepare for lay judges, and you do, right? But you're also going to see first year or second year out people who are college debaters who came along on these trips. You're going to see parents who have, in some cases, maybe never judged a debate before.
This is their little kids' big moment. They're coming out there because they really want to see their kid do well, and they just want to support them.
You'll have coaches with very strong philosophies and things along those lines. But there are all kinds of judges you're going to see, and you have to be able to adapt. One thing, you don't want to be too smarmy about it, but this is a tournament where, as you walk in the room, if you have a minute to have a short conversation with the judge without, what's your paradigm, but, giving them a second to talk a little bit, asking, what do you like to see, wouldn't be a bad idea, because they're all over the spectrum in terms of their preferences. And that goes to the third point, which is that there is no single guaranteed strategy at this tournament, right? No single way to win, but I will say empirically, the teams that can filter their strong arguments into lay judge friendly language always do better. You often see teams that have been successful at circuit style tournaments, but not every team that does well at circuit style tournaments is able to do it here, because not every team can filter those complex arguments into a simple, straightforward style.
It's a lot easier to go simple in your very first speech and expand on it later than to do really complicated up front and then try to reel it back if your judge doesn't understand it. You're wasting a lot of time if you're doing that.
That's a tactic I've actually seen judging at tournaments like these, like at NSDA and NCFL, that are big national tournaments that are lay judge friendly, which is teams will run relatively simple cases and then have widely divergent complex blocks and backup sets of cards and things like that ready to go depending on where the round goes. Hard to prepare like that, but it gives you a chance to sound very good in the opening speech and then take it wherever it needs to go with whatever evidence you need. The last tip is it's a long tournament, and this is a rapidly evolving. It's 4 days of debating if you make it all the way. This is a rapidly evolving topic. Like we said, just like the other day before we filmed this video, Congress announces hearings on the issue of tech antitrust. There will certainly be developments between this video and the actual tournament, and there probably will be developments during the tournament. And also you have to adapt based on what you see from other people, because it is so hard to predict. It's the only tournament on this topic. So, when you get an hour after the round, you need to be sitting down and tweaking. And certainly when you go from one day to the next in the hotel, you need to be doing that.
Yeah, and if you realize, like, in the first round, something, you're going to do practice rounds, or at least you should be doing practice rounds before you go to NSDA.
Yeah.
But if, during a round you figure out, okay, this card didn't really work that well, maybe remove it, change it a little bit, do something. Don't keep the same case day by day by day by day, because chances are it's either not working perfectly. If it is, great. But if it's not working perfectly, you can definitely fix it or at least improve it.
Yeah. I would say that there is virtually no chance that the cases that you hear in the final rounds will be cases that were run verbatim on the first day. People are going to be adapting to things like that, and you have to do the same.
They may have entirely different cases than the ones that they started
right.
with, the one that they're intentionally hiding until the final round so that nobody sees their cards.
I mean, if we're being real about it, but it's a competitive tournament. It's not easy. But look, just making it there is a huge accomplishment. Advancing at all would be a huge accomplishment. Great resume item, great thing for colleges and stuff like that. So not the only way to win is not to win the national championship. There's a ton of victory and accolades to be had just for being there. And certainly if you can maybe manage to make it out of a break round, that would be great. It's a marathon. Remember to stay hydrated and bring some snack bars and stuff with you. To
know how you're going to de-stress in between rounds.
Yeah.
Because if you're just wound up the whole time, you're going to go crazy. You're going to go ballistic and not be competing well.
Yeah, well, right. So anyway, just like any other big tournament, but bigger, right? Yeah. Just basically everything you normally do, but more, right? You know what you're doing because you got there. So those are the basic tips. Remember, it's a tournament that rewards communication. It's the kind of debate that we're supposed to be able to put on TV and have people watch. And by the time they get into the late out rounds, they really believe that. And a lot of these judges believe that too. And you need to be telling your story and keeping it simple. And then when you get to a point where you need a complex piece of theory or a card, that's fine. But telling simple stories will be rewarded. Okay, so let's start by breaking down the meaning of some of these terms. This is going to take a little bit of time because, frankly, the way they interplay and work together will affect how you debate the topic, and you'll see what we mean from that later. But let's just begin at the very sort of beginning of the resolution and ask, who are we talking about when we say technology giants? And so you can see here on this slide, we just took data from market cap. Market cap is just how much the company is worth in the market, how much that all of the stock costs. It's a way of measuring the size of a company. And we broke it down. We've got the top 10 from March of 2019, and we tried to show you kind of how they're very different, right? And you can see the usual suspects: Microsoft, Apple, Amazon. Alphabet, of course, is the holding company for Google, and then so on down the list. If you look at these, you're going to see these are radically different types of companies. And I apologize if we have any colorblind debaters. I forgot about using these colors. Maybe I'll change them from now until we put the video up. But I've color-coded what they do. And as you can see, for example, they do radically different things. Microsoft mainly sells software. It sells it to consumers and businesses. Apple mainly sells hardware. Amazon is mainly online retail, but as we'll see, they do many other things. Google is mainly online search, but they do many other things, and Facebook is social media, and so on. And what we can see is that these tech giants are all in radically different fields. They sell to different people. The color coding sort of shows you on this slide that in some cases, these companies are selling to other companies. In some cases, like Microsoft, they're selling to both consumers and other companies. And in some cases, like with Google and Facebook, they're not charging consumers anything, right? They're mainly selling advertising. And so you have a wide variety of different companies that we're talking about here. One of the interesting things about this is if you were to use a definition that were to say just, hey, the top 10 market cap companies in the world, it would be very difficult, frankly, for the pro, because you would have very, very widely diverging theories of like why these companies should be regulated. Look at these numbers 7, 8, and 9, Intel, Cisco, and Oracle. These are big companies and they're in the tech field, but they're really not like the others. They're not like Amazon and they're not like Google in the sense that they're just these world dominating companies that have no competition selling these sort of new fangled technological services. These are companies that do, it's kind of standard stuff like making microchips and selling them.
They just do a lot of it.
Yeah, they make processors and they sell them. They sell a lot. They provide network technology and solutions and they do a lot of it. But these are pretty standard companies, right? They don't have any sort of unusual features, and nobody's really debating whether or not antitrust does or should apply, for example, to Intel. Like if Intel went out and wanted to buy up all the other chip makers in America, you can bet your bottom dollar the FTC, the Federal Trade Commission, would step in and do something about it, right? So because you have so many different companies like this, I would suggest that maybe a better way to define tech giants, instead of just looking at raw size, right, is to maybe define it in context of the resolution. Sometimes in debate we say, look, we should use a definition that's consistent with like why we're debating this, like how it's actually being debated in the real world. And if you look at the sort of companies that are in the news right now, this is from literally yesterday. This is the House Judiciary Committee launching its tech antitrust inquiry, and it says that the companies that it's going to focus on are Google, Apple, Amazon, and Facebook. When you look at the European Union and how it's been taking an interest in antitrust and tech companies, it's Google, Apple, Amazon, and Facebook. Sometimes we add a fifth one, of Microsoft, to call them the big five, right? But at the end of the day, these are the companies that are part of the real world public debate. So maybe one thing that you can do is, I would think a more manageable debate, probably an easier debate, certainly on the pro side, would be to say, we're going to limit this to the companies that are being discussed as sort of tech giants in the field of antitrust or for purposes of antitrust.
Like we acknowledge that, other companies may qualify as giant monopolies or have their hand in the market in a sense, but they're not really what we're talking about. There's a reason this topic came up, and it's talking about these companies.
It's not talking about Intel going out and buying up all the chip makers. That's not happening, and nobody's debating it.
We got to fix Oracle. They've got too much market share.
So, Judge, let's limit the round to the 4 big companies, or maybe the 5 big companies that are actually being debated as part of the major problem of how we enforce antitrust. A contextual definition. Yeah. It makes for a better round, a more educational round. Hopefully, many teams will agree to it. I would suggest if your opponent does it, maybe just be okay with it, because if we have to say, well, yes, you've proven that Google and Facebook need regulation, but you didn't talk about Cisco systems. Nobody's here to debate about Cisco systems, right? So anyway, just a thought to kind of slim things down. I think it's a fair way to limit the round. So what are antitrust regulations? Now, I've seen some folks kind of trying to put out some information on this for purposes of this topic. And they're doing the best they can because there's a lot to it. And even as a lawyer, myself, there's a lot to take in. But let me do my best in a nutshell to lay out what I think you need to know about this 130-year-old field of law. Okay, I'm going to do my best. Here I go, right? So antitrust laws are basically what we would consider pro-competition laws. They are built on the principle that consumers are better off when companies have to compete against each other, right? We're basically a capitalist country. We basically meet our needs through capitalist competition, and competition makes these companies do a better job. It lowers prices, drives innovation, increases quality. But when one company, through whatever means, manages to dominate the market and either becomes a monopoly, or maybe a few companies come together in an oligopoly or what's called a trust, consumers are harmed, right? Consumers are made worse off. Now, in the United States, antitrust law has been around for well over a century, and it comes from 3 main statutes, as well as the court decisions and administrative regulations and interpreting and applying those statutes. I hope, and I'm pretty sure, that nobody in public forum debate with 4 and 2-minute speeches is going to delve into a lot of depth about a particular regulation or a particular case, but there are 3 statutes that you need to know. And those statutes are the Sherman Act, the Clayton Act, and the Hart-Scott-Rodino Act, which gets left out a lot. So let's start with the Sherman Act. This was the granddaddy of them all, or the grandmother of them all, to be gender neutral. But basically what was going on back in the 1890s is companies like Standard Oil were getting together with their rivals and saying, hey, wouldn't it be neat if we didn't have to compete and lower our prices against each other, literally twirl. This was the era of like literally twirling mustaches. If you've played Red Dead Redemption 2, it's pretty much like whoever the bad guy Cornelius Vanderbilt was like in that game. But like they said, hey, some very creative lawyers said, why don't we create these things called trusts? And we'll in these trusts, what we'll do is we'll put all of our stock in a pool and we'll appoint some trustees, and those trustees will make rules that we all have to follow, including setting a price. And don't worry, we'll set the high price nice and high, right? And then none of us can go below it, so we don't have to worry about competition. And obviously this increased cost to consumers, and it was bad. And so Congress got involved and outlawed these trusts. And the Sherman and as they say, and it was good, right? But the problem is, evil lawyers do creative things, and they found new ways to sort of conspire together to avoid competition. So in 1914, the Clayton Act comes along, and it recognizes that the Sherman Act was good as far as it went, but it wasn't enough. Because now these companies are figuring out, okay, if we can't form a trust, why don't we just merge, right? Why don't we just get together and form...
Instead of having an unwritten agreement, we'll just make it written.
We'll just get married, we'll just do it formally. And they get together, and then when you merge and you have enough of the market share and you're a big enough company, you can charge whatever you want. And so the Clayton Act was aimed at being a more sort of practical, let's look and stop the behavior that leads to these monopolies before it happens. And so, for example, it said things like you can't have coercive buying agreements. You can't say to like a buyer, hey, if you buy from any other company, we won't sell to you. Like if you were the oil seller for a particular town, you can't say, well, if you buy from them too, we won't sell it to you. You also couldn't engage in predatory pricing. Predatory pricing is defined as selling below your own cost, right? Like taking a loss on your product, right? For the purpose of driving your competitor out of business.
Which is going to come up later. We're going to talk about
it will. We'll talk about that later, right? But the idea being that like it costs you $10 to make your widget, and you sell it for $9, and you take a loss with the idea that you can endure it longer than your competition, and your competitor will fold up shop and leave town, and then you'll raise the price back up and make more money because you are effectively a monopoly. And it also created the Federal Trade Commission, the FTC, which is of course the agency, along with the Department of Justice Antitrust Division, that enforces these laws. Lastly, and the one a lot of people leave out, is the Hart-Scott-Rodino Act. This was just a little note. In 1976, they realized that by the time a lot of these cases made their way to court, right, the Department of Justice Antitrust Division, for example, challenged a merger. They said this merger is leading to a monopoly. We can't have that. The company had already signed the papers and been operating and merged, and it was often difficult to pull them apart. So what Congress said is, what we need to do is, if you're a big enough company, if you're bigger than a certain threshold, or if your merger would make you bigger than a certain threshold, you have to come to us and get permission in advance before you merge. And this is why the FTC, we hear about them reviewing mergers and either approving them or not.
We see this with Disney pretty much any time now they buy pretty much any sort of platform. They're like, all right, this might be an issue. We'll probably allow it, but we got to check first.
Right. So that's the real quick rundown of antitrust laws. The next term is antitrust regulations. We've already talked about what antitrust is. A simple definition. I know that most folks don't read definitions anymore in PF cases, but if you happen to need one, Cambridge Dictionary, relating to laws or actions intended to make business competition fair and prevent any company from being a monopoly. Very good layperson definition. It's correct, okay? Regulation can have two meanings. I think the good one here that I have a happy face by is just a simple, plain English language definition and official rule or law. You could use the hyper-technical definition that looks at... Go ahead.
Yeah, well, the thing is, if you read this definition to me and I'm a judge, about 14 words in, I'm zoning out.
Yeah, I mean, I don't think anybody would read this stuff, but you never know. The reason we list some of these things is because people get squirrely, right? But anyway... For lawyers, the word regulation has a term of art meaning in the sense that it's not a statute, right, passed by Congress. It's not a court case, like a court decision. It's a rule put out by a federal agency and put into what's called the Code of Federal Regulations. Don't do that, right? But be aware that some cute team out there could try to say regulations. What that would end up doing is it would gut out about 98% of all antitrust law, and it would leave you with a few things about like filing deadlines.
And you know what? Hey, if that's what they want to go with, sure.
Well, except that they can like ambush you, like filing deadlines should apply to tech giants. Well, yeah, I mean, of course they should, right? But don't do that. Yeah. Just be aware that could be used, don't do that. And this leads to a question, though, like antitrust regulations, like the phrase enforce antitrust regulations. We're going to come back to this again and again and again. But does the phrase enforce antitrust regulations and the absence of other verbs like enact or implement or pass or anything like that mean that the pro must advocate laws that exist in the status quo? And we're going to talk about this a lot, but basically the argument I make is if the resolution said resolved the police should enforce the speed limit, right? That does not mean that the question is not, do the police go out and set a new speed limit, right? And so what you could argue is by saying enforce antitrust regulation, not only does it permit the pro to advocate for the status quo of what the law is now, it arguably requires it because, enforce the speed limit doesn't mean set a new speed limit. Enforce antitrust regulations is not the same thing as saying pass new antitrust regulations, right? So anyway, last thing on my whirlwind tour here of the law. I know Josh is getting frustrated with me spouting like legal dicta here, but we're going to do it.
It's a lot.
It's a lot to it's a lot to take in, guys.
But the problem is, it's important. Like all of this is important.
I will tell you, we spent. If somebody comments on this video and says like, "Oh, this video was too long," I spent like 3 days cutting this down to like less, just the stuff you need to know.
And the other thing is, the reason we're doing this is that if you don't know this, the debate's gonna go poorly.
Yeah, if you're the one,
this is really important stuff.
If you're whoever the one person is that always dislikes our videos, like if it's because it's too long, go ahead and dislike it.
It's actually just me on a different account.
Fair enough. Just go ahead and dislike it now because it's going to be long. But anyway, what do the federal antitrust statutes actually say, right? I'm going to put this up on the screen. This is an example of you might want to screen grab this, or you might want to pull it. Hopefully we'll have it up on Twitter.
Pause, read it before we get into it, and then come back to it.
You don't really need to know all of it, but the highlighted parts. But anyway, basically, if you look at these are the major sections that are the main enforcement provisions of the Sherman and the Clayton Act, right? They're all together in one section in the U.S. Code. And if you look at these words, like the operative verbs, like monopolize, or for example, attempt to monopolize, or lessen competition, or restraint of trade, what do all those words mean? You might assume that they're defined in the statute, but they're not. Right? There's no definition in there. And that means that courts have had to figure out what these words mean through years of case law. And that case law is heavily influenced by economic theory. And let me very briefly explain why. Obviously, we don't want to stop every restraint of trade, because if I'm just really good at competing at something, like I'm a good business.
I mean, the point of capitalism is to kind of restrict your opponent's trade.
Right.
At least a little bit.
I beat you in the market for widgets. You go out of business. I have restrained your trade, but I do it honestly.
I make a better product.
Yeah, just make a better product.
I advertise better, stuff like that.
So clearly we can't have meant when we wrote this statute anything that restrains Josh from selling a crappy product or me from selling a crappy product, right? We can't, that's not what it can, lessening competition, it can't just mean that we've got 100 companies and 90 of them go out of business and we have 10 left. So we have to figure out when should we enforce antitrust is a question that has been left to the courts. It's not every time competition goes down. And the question of when should it be enforced has been left largely to a question of economic theory. Economists have gotten heavily involved in writing the legal briefs in this field. And what you end up seeing, and okay, this is really the last slide on the theory of antitrust, right? What you've seen is two basic theories of antitrust enforcement, right? And this is where the issue that we have in this resolution starts. And you need to know this history. If you don't know it, you're going to have a problem. But for a long time, antitrust enforcers took what was called the structural or the structuralist approach. And this basically looks holistically at all the circumstances of a company's behavior. Are they pricing below their cost of production? Are they, threatening buyers and competitors? Are they merging vertically and like a shoe manufacturer buys a shoe store and then, oh, look, maybe the shoe store only sells from the shoe manufacturer. It just looks at all the circumstances and it kind of takes a skeptical view at anything that might lead to less competition, right? It's a very, I know it when I see it, consider all the factors kind of thing. And it's a thing where you might have a few situations where you find an antitrust violation where maybe there wasn't. It tends to err on the side of being more aggressive rather than more restrained, right? And this is what we did from basically the beginning of the Clayton Act era through the 1970s. But in the 1970s, we had a bunch of free market economists from what's called the Chicago School, including a lawyer named Robert Bork, come around and say basically, look, this is too much. You are putting too much scrutiny on these poor, benighted companies. You shouldn't care about mergers unless they do one thing and one thing only. And the only thing you should care about is whether they directly harm consumers. Usually, right now, usually through raised prices. These conservative free market economists said it doesn't matter if one company underprices its goods or drives another company out of the market or even kind of cheats here or there. That's not an antitrust concern. The only thing that should matter is if it uses whatever market power it has to raise prices or directly hurt consumers. This was a very narrow view of antitrust. It did not look at all of the circumstances. It didn't try to figure out the future or predict what was going to happen. It said, look, if they run you out of business and then they start gouging their customers, fine. If not, then it's not a problem. And the thing I analogize it to is if you've ever seen the situation where like you drop a frog into a pot, right, and you gradually slowly turn up the temperature, and you know, a structuralist would say it looks like the temperature is going up. We should do something about this. The consumer welfare free market person would say, "Are you dead?" Right? Is the frog
actively boiling alive?
Is the frog literally boiling alive? If not, then you know, no harm, no foul.
It's like that. It's like the picture with the dog in the room that's like on fire, and he's like, "Yep, this is fine.
Yeah, this is fine. This is fine." Yeah, but consumer welfare, and look, I'll pop down to the next slide, which is consumer welfare. Really that's kind of a euphemism. It's really more, are consumers being directly harmed right now? These are free market theorists, right? And the basic idea is that this is not an approach. And so, for example, if I go back to the slide before, Lena Khan, this is an article we popped up on Twitter. You need to read this article. Okay, Lena Khan is a genius. She was in law school when she wrote this, which would normally mean I'd tell you to take it very carefully, but she immediately like rocketed to the top of antitrust scholars. This is one of the seminal articles. You need to read the whole thing. But she explains how this shift in enforcement priorities in the 1970s and the early 1980s, how the Supreme Court and how the federal government adopted this very narrow consumer welfare approach that really only looked at prices, and how that meant that they were not able to effectively regulate these companies. And so that leads to the question, why is this so-called consumer welfare approach a bad strategy for policing tech firms? And again, read Lena Khan. She will explain it in depth about how this became the law, right? Price-focused consumer welfare became the test for whether we're going to do antitrust enforcement, right? And it now, the argument that she makes and other people, like this article about why it's time to break up Facebook, they all make this argument. This approach cannot account for the problems we see with tech companies. So a couple of reasons, and you can read over these and they explain them. The first one is tech giants play the long game, right? Amazon has spent well over a decade driving companies out of business, underpricing them, using the data they collect from their sellers to compete against their sellers. And all the while, they have kept prices on consumers low. But they have said many times that their goal over the long term, and their shareholders have supported them in this, that most companies, they want a profit. Amazon shareholders know that their game is over 20, 30, 40 years. They are totally fine with lowering prices on consumers as long as they keep growing their market share. And their market share now of e-commerce is massive. Yeah. Right?
I mean, the idea is if they're, you know, say they want to be an online retailer, if they're they're worth $900 billion,
yeah,
they can take a little bit of a loss on shipping. They can afford to give you Amazon Prime for $50 if you're a student because they've just got that much money. And the mom and pop shop down the street doesn't.
And they do it all the time to the mom and pop shop and the other online retailers to drive them out of business. The consumer welfare free market Chicago School approach, which is our current approach, says
that's perfectly fine.
We don't care because prices on consumers are not going up. The structuralists would say, this is a problem, right? I mean, this company may not be shafting consumers now, but if we let them continue to do this, they're going to be like running the economy. They're going to be like one of these, dystopian future mega corporations that like owns its own planet, like Weyland-Yutani from Alien or something.
Or like SpaceX probably will in 30 years.
Yeah, exactly. But, and the structuralist would say, we've got to do something. The consumer welfare would say, well, if the prices aren't going up, we don't care. A couple of other reasons. Tech giants often don't charge consumers prices for their services. How can a theory that looks overwhelmingly toward whether prices are going up, it doesn't look exclusively to that, but it does look overwhelmingly to whether prices are going up, how can that effectively regulate companies like Facebook and Google? You pay Facebook and Google with your data, right? You pay them with them extracting information about you and using it to advertise. These theories from the 1970s that we currently use to decide when antitrust is enforced have no good way.
They're not making steel. They're not making oil.
Right.
There's no tangible product to say,
buggy whips.
This is bad.
Yeah, exactly. And then the last reason is tech giants benefit from creating platforms that kind of give them quasi-monopolies, right? A lot of people don't like Facebook. Like my mom used to, and my dad will now complain about like, they don't like Facebook and they don't like the data. It's like, why don't you leave? Well, because all my friends are on Facebook. That's where they are. Facebook is providing a service of connecting me with my friends and I can't get away from it. Amazon is so large that even sellers that compete with Amazon, like they sell the same things Amazon does, have to use Amazon because that's the only way to reach millions and millions of consumers. And they know in doing it that Amazon is going to harvest their sales data and use it to figure out how to sell a product better than them. But they have no choice.
And Amazon's so big, they can sell to every little podunk town in places like Mississippi better than most other like online retailers probably could.
Right.
They can get a package anywhere in 2 days.
Yes, exactly. Okay, so that's the basic reason. We don't have enough time to go into it in any more depth. We've got to move on. But basically, you've got to be aware of why this whole theory, this paradigm shift in the late 70s and early 80s means that tech companies don't get enforced. I'm going to skip ahead just a little bit in the interest of time. You need to be aware of sort of the current events or what is going on in the world of antitrust enforcement. Be very literate on these things. I'm going to give a whirlwind tour really quickly. First of all, in February 2019, the FTC convened a FTC Tech Task Force. This is basically like a mini division of the Federal Trade Commission with 17 staff attorneys. Frankly, it's not big enough to mount its own like litigation. You would think 17 lawyers would be enough. That should give you an idea of how big antitrust lawsuits are, that they couldn't effectively do it. But it is designed to sort of look and investigate and figure out whether there are antitrust problems. This was followed up in June of this year with the Department of Justice. Remember, their antitrust division is sort of the litigation arm for antitrust enforcement. They and the FTC got together and basically divvied things up. They basically divvied it up so that the Justice Department is going to focus on Google while the FTC is going to focus more on Amazon. So they're sort of trying to divide and conquer. And, this is going to come back again to, does this action that's going on now constitute enforcement? Is this creation of a task force, creation of an agreement, is that already enforcement? Can the pro say, look, we've already got the process. Investigation is part of enforcement. Let this investigation play out. The enforcement is already happening in the sense that you have to investigate before you can enforce, and that's already happening, right? That's an interesting potential wrinkle that the pro might use. And then, very briefly, lastly, this happened just a couple of days ago. Congress has announced that it's going to convene hearings about the potential antitrust issues surrounding Google, Apple, Amazon, and Facebook. This arguably wouldn't involve enforcement directly because Congress is not a law enforcement branch, right? They're a legislative branch, but the things that they find and the information that they discover could affect how enforcement occurs, right? So you've got to be aware that those things are happening. And again, one question that's going to raise is, and this is really important, so we're going to spend a minute on it. Given that antitrust laws, by the literal text of what they say, and clearly apply to all industries. Right. There are no exemptions in the actual antitrust laws, like literal exemptions for tech companies or anything else. The only exemption in antitrust law is actually for labor unions, but none for tech companies, none for any specific industry. And given the fact that over the last few months we have seen ramping up of the investigation process, and given the fact that litigation does occur in these fields, can and or must the pro say, look, I don't have to come in here and advocate for some newfangled, additional level of antitrust enforcement as long as you agree, Judge, that antitrust laws generally, whatever they say, even if they're not fully adequate to the problem, but whatever they say, if you agree that they should continue to apply to these companies in some way, then they are enforced in some way, and therefore the pro should win. The question as phrased is, are antitrust regulations currently enforcing the status quo against technology giants? And the answer is yes and no. The word enforce means to cause a law or rule to be obeyed. It does not necessarily mean filing a lawsuit. Again, with the speed limit analogy, if the police are out sitting on the side of the road with their radar guns, and I see them, and I drive slowly, and they don't stop me, are they enforcing the law? Most people would say yes, in fact, they are. If the FTC exists and watches for, really egregious things like a massive merger by Amazon,
and create a task force to deal with it.
Creates a task force to deal with it.
Or not even deal with it, to see if they need to deal with it.
Isn't that causing a law or rule to be obeyed? Now, you might say, I think the rules should be different. The rules should be better. The rules should be more aggressive. But arguably, the resolution doesn't talk about that. It doesn't say enact new rules. It says enforce antitrust regulations, right? Anyway, so here's the argument for why, yes, in fact, we are, the status quo is enforcing. Number one, we see plenty of action by federal agencies to literally enforce antitrust laws against these companies. Look at, for example, the United States versus Microsoft antitrust case in 1999, which led to a massive settlement, could have potentially led to a breaking up of Microsoft over some issues with its bundling of its operating system with its Internet Explorer. Clearly, that was enforcement. That was a long time ago, but even more recently, the Supreme Court, which is a part of the federal government, it's not the enforcement agency, but it is a part. By allowing a lawsuit to go forward, it was playing its part in enforcement. It allowed a suit to go forward against an antitrust suit against Apple over its App Store, and this was just a few weeks ago in 2019, Apple versus Pepper. And then, of course, this spring we've seen all these steps like the FTC task force, the interagency agreement, the congressional hearings that have just been called. Clearly, there is enforcement going on, I think, is the argument. And you can just sort of make the argument. I've sort of laid out the argument here. I'm not going to read it, but the basic idea is you might say that antitrust law is not terribly effective, but nobody thinks that there should be no antitrust law against these companies. Even if you think that antitrust law can't solve all the problems that they're creating, nobody thinks that, for example, if Apple wants to buy Microsoft, right? And
sure.
And so nobody thinks that shouldn't be subject to antitrust scrutiny. Nobody thinks it wouldn't be. It clearly would be. And the argument would be, even if those laws aren't good enough, they're way better than not having anything. Nobody thinks we should get rid of them. No responsible person does. And that's enforcement. Maybe you think there should be more enforcement. Fine. But that's not our burden as the pro, right?
And also, for those of you on the con, if the pro is saying oh, you have to say by negating this resolution that there shouldn't be anything like that, or we should get rid of them, or they're not effective, say, that's not necessarily what we have to say. We don't have to uphold that.
Right. And so the counter, exactly. And the counter argument would be, the con is going to argue, no, pro, you cannot just come in here and simply uphold the status quo and say, oh, well, if we have some bare bones minimum level of enforcement, that's all we need. And then we're going to talk later about the arguments for that. But the basic idea is what you do is you say in the 1970s and 80s, the Supreme Court and the FTC basically said we're only going to enforce antitrust when these companies are raising prices and directly harming consumers. And we will put in the notes below numerous sources, and we'll talk about some of them later, where they basically say that's not enforcement, right? That's not enforcement in the sense, it's enforcement in the sense that we're sitting out on the side of the road with the radar gun,
but it's a toy gun, or it's just your finger.
But we're letting all the cars go by, right? I mean, in theory, I guess we're watching people drive by and violate the law, but we're not doing anything about it.
Right.
And so the argument would be, basically, the con would say, enforcement has to mean meaningful enforcement. It can't just be, well, there's a law that applies to you, except it never actually applies to you.
If the courts could never bring a case against Facebook because they don't actually sell anything, then what's the point of having regulation in place? Clearly, they're not enforcing it by having the regulation there because there's nothing they could actually do under the current interpretation.
So with that is the kind of long-winded explanation. I told you it would take a while, but this is a deep topic of kind of what we're talking about here. Hopefully you have a little better understanding. Even with all this 30 minutes we've spent talking about this, you're still going to need to go and read through these things. We're going to have a ton of sources in there, and you're just going to have to read until you understand it. But at least now you kind of have a roadmap.
Yeah,
for it.
And we're done with framework. We're getting on to like the actual pro and con strategy.
Yeah, this will be more fun. So let's do some pro strategies right about now. Okay, it's pro time. Let's do this. We're going to do basically a breakdown of sort of 3 general strategies that we think the pro can take. And then we'll talk about a couple of sort of prerequisite things that I think you need to think about in every case. And then we'll just move on and start talking about like some ideas for specific arguments. Obviously, these are not exhaustive. We've tried not to spend a whole lot of time talking about stuff that's like fairly obvious. We're not going to spend a ton of time, for example, just reading you numbers. We'll put some of that in the sources below, but there's not really any point in that. We're hopefully going to just kind of give you some ideas of directions you can go in.
That's kind of the thing that y'all need to read. It's going to be way more beneficial for y'all to read it and understand it than for us to read it to you and you think you understand it.
Again, if you've not been to NSDA Nationals, the people that are rewarded, frankly, are the people who are just like on lockdown, just reading, practicing, hopefully doing some practice rounds. If you don't do that, then there's no specific piece of information that we could give you. And I know that all of you are because you're here spending your time with us and we love you for it. So anyway, 3 different strategies that you can take. As you can see, I think that 2 of these are good. One of them is but a lot of people are talking about it. So let's just go through them.
We're including it so that hopefully you don't do it, or you'll recognize it if someone does do it.
And somebody will do it because we've been seeing it. Okay,
so hopefully now you've got a gotcha.
Yeah. Okay, strategy 1. We've been talking about this, but let's just lay out how this would run, okay? Strategy 1 is the pro coming in and saying that enforcement of antitrust regulations is happening right now. It's the status quo. Right now, all 3 branches of the federal government are actively investigating potential antitrust violations if you include the Supreme Court allowing the Pepper case to go forward, right? So all 3 branches are actively investigating antitrust. How could we possibly say that antitrust regulations are not enforced in the status quo? All 3 branches are doing it, right? Investigation is the first necessary step in the enforcement process. That's what 2 of the branches, or at least the executive branch, is doing right now. Also, we're seeing actual prosecution and litigation go on occasionally, right? Therefore, if you believe that what's happening right now, like just we occasionally investigate, we do occasionally stop the most egregious things, like where there's a merger that's not, that's totally unacceptable, and the ongoing investigations where we look and see if there's a problem. If you believe that that's good and we shouldn't stop, like we shouldn't give these tech companies a pass and just say, nope, no more enforcement, just any level of enforcement should be enough, and therefore the pro wins. It doesn't say total enforcement. It doesn't say effective enforcement. It just says enforce, right? And so this is, I thought it was kind of shady until I started seeing how these new task forces and agreements started stacking up in the spring. And there is a colorable argument. People say, how can you say there's no enforcement happening now? All they've done over the last 6 months is enforce.
And a good tangible case of that is Apple versus Pepper. Like they literally this year have made a case and made a decision about it.
Yeah, the Supreme Court has said this case can go forward. Now you might say that's not enforcement. I would say that's exactly how enforcement works in a court. They say go to trial, prove your case, right? The pluses of this are there aren't a lot of tangible disadvantages. You can't really argue that antitrust shouldn't apply to tech companies, that they should get a pass. Also, there is a sort of appeal to experts argument. Like all these smart people in these federal agencies are gearing up to figure out whether there's a problem. Why should we stop them?
And chances are they know a lot more about it than we do, so who are we to say?
Right. Why don't we just let them see if they can figure it out? Why stop them now? This is part of enforcement. Let it happen, right? The minuses are basically this all turns on one critical sale you have to make to the judge, which is that we are in the status quo enforcing. If the con turns that and says you've just advocated for the status quo, right? You spent your whole case saying status quo good, right? If the con comes in and says the status quo isn't really enforcement. We've had this theory of consumer welfare that does not allow enforcement, judge. You've got to look to real enforcement. That isn't it. They just turned your whole case. right? They just completely 180'd. They turn the case, turn the round, and should, in assuming the judges are competent, win the round based on that. So there's a big risk there, but it basically becomes a debate about nobody really thinks that the bare minimum stuff going on now is bad, that it should go away. So is it enforcement or is it not? I don't think the NSD intended this debate to occur. There's no way you can predict all the legal permutations. I do, however, think that this is something you will see from some people. I've seen it being talked about on Reddit already. So it's going to happen, and you have to be prepared for it. Strategy two is probably my favorite one. And it's a more straightforward and fair argument, I think, which is basically, look, enforcement means that we're going to abandon this like rigid consumer welfare rule where we only look at price, and we're going to go back to this more inclusive structural rule. And we'll show you, in the notes below, and I may pop up a few slides about how there is plenty of literature out there with people calling for this. They say, look, we used to have, this is not enforcement right now, right? We used to have a method that worked. We would look at the totality of the actions of these companies rather than just whether they're raising prices. And what we need to be doing is looking at how Amazon goes out and undersells its competitors and drives them out of business, and how Facebook uses your data, and how Google uses your data, and how they create these platforms that require competitors to compete like against themselves. And if you do that, you will clearly see a problem. And the Lena Khan article shows you that, right? There is a very strong academic literature base on this. It is probably the soundest real world argument. In other words, this is the argument that the real world advocates for reform are making.
The only problem is those real world advocates have infinite time to explain it, and they're really, really knowledgeable on it, and you have 4 minutes.
The downside of this is it is a theoretical argument, and you're going to have to really, really work to explain it. You're probably not going to be able to read long cards. You're probably going to have to take a 2-sentence excerpt and or paraphrase in some places, and you're going to have to be really ready in crossfire to explain exactly how this works. But the basic story you tell is, up until the 1970s, we had a system that could look at the holistic system and enforce it against complex new companies. In the 1970s, we abandoned it. The Supreme Court abandoned it. The federal agencies abandoned it, and we need to go back to it, right? That's the story that you tell. The only other weakness on it, I think, is it is vulnerable to simplistic arguments like, if prices are lower, who cares, right? And you have to be able to fight back on those. Some judges who are not super inclined to listen to a lot of deep theory might be like, yeah, prices are lower, who cares, right? But if you're able to explain why these structural problems lead to harms, which we're going to talk about in just a second, you'll be in good shape. The last one, and the one that frankly I don't like for a lot of reasons, but one that has been talked about like a lot of places that are discussing this topic, is the idea that we're basically going to run a plan. Now, I know what you're saying, you can't run a plan, but we're talking about in NSDA rules, you can have a common sense solution. Well, this is your specific real world common sense solution. In other words, you take some proposal that exists in the real world, like for example, the Elizabeth Warren plan, right? You take like the Elizabeth Warren plan and you run it and say, let's do this, okay? Antitrust enforcement is outdated. Let's update it by passing Proposal X, and here's how Proposal X will work. The benefits of this is, number one, it's a little less predictable if you, I guess, maybe pick, most people are going to prepare for the Warren plan, but if you pick something more esoteric, maybe you could catch somebody off guard.
It doesn't really matter whose plan you're picking. The fact is, even if you're not specifically implementing a plan, this goes on to the big issue with it, is this idea of topicality.
Yep.
Like saying you want new regulations isn't really what the resolution's talking about. That's the whole point of enforcing, kind of like what Brett was saying earlier. Putting a new speed limit in isn't enforcing current speed limits.
So yeah, there's a ton of, yes, that's the first big thing, right? The resolution asks us to enforce antitrust regulations. Regulations implies that we're talking about things that exist. Enforce implies that make them operate. It doesn't say enact. It doesn't say pass. It doesn't say propose, create, anything like that. So number one, you're going to get topicality attacks that say, you're trying to change the law. Yeah. The question is whether we should enforce the law. You're non-topical.
The fact is, if NSDA wanted you to talk about changing the law, they would have put it in the resolution. Simple as that.
Probably should have. Don't tell them I said that. I love them. But seriously. But anyway, the other thing is it could also be attacked as a plan, right? And anything you run can be attacked as a plan. You got to have that tedious little argument about, well, it's a common sense solution. No, it's not a plan. And then, it in some cases, depending on specifically what it advocates, you may have a hard time linking to some benefits.
And so, big thing from this, basically, be on the lookout if someone does do this.
Yeah.
So you can call them out on
topicality,
or
right? Yes, exactly. Like hit them on topicality. But running a new legislative proposal is just dumb. I mean, I'm sorry, it is, right? Don't do it.
But also, yeah, it's hard to quantify it. Like, we're going to hope that this stuff happens, and maybe it will. Like, you have pretty much zero evidence to say what you're planning would actually work. Yeah.
It would have been a much easier thing if somebody had picked, like, a particular proposal and just made that the resolution. I know that you guys want to have more breadth and stuff like that, but it would have avoided some of this stuff about the status quo being a topical advocacy. Yeah. But we didn't do that, so here we are.
A bit too much breadth.
Right. Two things you need to do as the pro, no matter what case you run, well, almost no matter what case you run, is you need to basically, number one, explain why the status quo is bad, and number two, explain your solvency story, like why your advocacy, whatever you're running, solves the problem. So right off the bat, of course, we're going to be talking in just a second of substantive arguments about why the status quo is bad, but you need to avoid relying on crutches, vague crutches, like they're just so big and so influential and they have so much influence on our life. That's not concrete enough. You need to be able to explain in particular specific terms why right now having these massive tech giants is harming people.
You're not a politician. You don't get 5-word sound bites that sound good. You have to actually like explain stuff.
Yeah, you need to have bullet points ready to go about why present tense the world is worse because these companies are big. So for example, explaining this idea of these little tech startups being in the kill zone where they either sell out at a low price or they get like copied. Explaining how consumers have no alternative to Facebook, how Amazon kills off its competitors using their own data, about how it lowers wages and wealth distribution, and all these other impacts. You have to be able to explain that briefly, succinctly, bang, 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 not just they're big and influential. That's not good enough. And that leads to the next point, which is your solvency story. And when I say solvency story, I mean your ability, not just in like reading the case, but also in like crossfire and rebuttal, to explain succinctly why whatever you're advocating is going to make it better, right? Now, if you run a status quo is good case, first of all, initially when I drafted these slides, I had like a Emperor Palpatine dark side, picture associated with this case because I thought it was kind of shady and evil, and maybe you do too. But again, so much has happened in the last 6 months that it's kind of hard to arguing that the status quo is enforcement is a terrible, evil thing to do.
There's not a whole lot you could ask of the government to do right now, like as is, other than just make more task forces or illegitimately sue companies.
There are responses to that approach, but it's not like so shady that it's clearly only the territory of like malevolent bad debaters, right? Anyway, so if you're running that case, all you really have to do is say that antitrust enforcement, as a general matter, at some low basic level should happen. If it didn't, that would be bad, right? And don't want to take it away, don't want to shut the task forces down. That's easy. If you are running other cases, though, you need to explain how it solves. So, for example, looking at the bottom here, if you run a specific policy case, well, that's easy enough. You're going to look at what that policy does, and you're going to link to specific advantages. So, for example, if you run Elizabeth Warren's plan and you say, well, first of all, you're going to have a topicality problem because she herself says that most of her plan involves new legislation. So, that, caveat emptor, right? Buyer beware. But even if you do, like you run the other half of her plan, which is about like unwinding these tech mergers, right? She says we should unwind these big mergers of things like WhatsApp and stuff like that. You then have to be able to explain what happens as a result of that, right? In plain English. Now, the more challenging thing is if you run this sort of let's go back to the philosophy that worked case, let's go back to the holistic structuralist model before the 1970s, you have to explain how this is going to benefit. And the thing about it is you're not going to be able to say X will happen, like Facebook will be broken up into these groups, Amazon will be required to do this. And the response, if the con asks you to do that, is, number one, I can't do that. This is neither can you when you're the pro, right? In public forum debate, I'm not allowed to offer a specific plan, so it would be unlawful or against the rules for me to do that, and it's unfair of you to ask me how exactly this is going to happen, right? But number two, what I can tell you is that right now we're effectively doing zero enforcement, or at least zero meaningful enforcement. And if we do go back to this philosophy, we'll have a greater than zero chance of stopping this abuse and this abuse and this abuse, whatever your abuses are, right? Our chance of stopping these things will go from 0% to some positive percent, and that's an improvement.
And on the pro, a way you can kind of codify this is if your con opponent comes up and talks in their entire case about how antitrust isn't doing anything, so we should get rid of the antitrust system because it's not doing anything, be like, yeah, I agree. Right now, under the current philosophy, it's effectively doing nothing. That's why we need to change the way we think about it, because you're right. It's not doing anything right now.
Right. And the good thing about antitrust law is it is incredibly flexible. I mean, if you read the Clayton Act, it actually gives courts a lot of leeway to fashion remedies. It doesn't just have to be we break the companies up. For example, in the Microsoft case, the court, it was pursuant to a settlement, but the court entered an injunction requiring Microsoft to share the source code for its software so that other companies could effectively compete with their media browsers, right? So these courts can get creative in terms of what solutions they're allowed to use under antitrust law. It doesn't just have to be we break the company up. There are a lot of different things you can do. And you can say, I don't know, and I can't tell you, and it's not fair of you to ask me to tell you exactly what these courts will do. What we know is that under the current approach of non-enforcement, it will never happen. And that if we do change back to the structural approach where we do try to scrutinize these companies, there is some non-0% chance that it will happen.
And then real quick, if your con opponent, like, you go on to the whole spiel about we're not making new regulations, and your opponent says, well, if we're changing philosophies, isn't that kind of like we're not enforcing the current system? No, that's different. Like, whenever we're talking about changing regulations or enforcing regulations, we're talking about the current legal, on the books, Code of Federal Regulations thing. Whenever we're talking about philosophy, we can change philosophy and still be enforcing the same regulations. Yes. We're just changing how we're enforcing.
We're not changing the law. These philosophies or enforcement are things where the courts have basically said, I acknowledge antitrust is an issue here, but we're just not going to apply it. Right. Where the Justice Department and the FTC have said, this is not going to be a priority for us. We're not going to bring enforcement actions. The law doesn't change. The Clayton Act, the Sherman Act, none of that stuff actually changes, right? What happens is when the government actually thinks it's worth getting up off its behind and doing something. And in the 70s, it said, if it doesn't affect prices, we don't think it's worth getting up off our behind. And we basically want to go back to when they did think it was worth getting off their behind and doing something, right? Okay, let's talk about specific arguments, finally. Okay, let's do it. Okay, so first, we're just going to go in here's a bunch of arguments. Rapid fire, here we go, boom, boom. Pro argument, just random order number one. Amazon uses its market power, and this is Amazon specific, but you can apply this to other companies as well. But Amazon in particular uses its market power to control its competitors and also its customers, and thereby control the market. Basically, this is a story about how Amazon effectively, it is not only a retailer, it's also a seller, right? It sells its own products, right? And things like that. And what it has done, if you read this article in The Nation, by the way, this Nation article is another required reading thing. This is great, plain, common sense English language explanation. But basically what it's done is it said, look, third-party seller, we're so big, you're going to have to sell on our platform. So you're going to sell on our platform, and here's what's going to happen. We're going to take your data, and we're going to look at how much you're charging, and how much you're selling, and who's buying, and when they're buying, and then we're going to go out and plot on how maybe we might be able to come in and beat you at your own game. We might start selling the product ourselves, we might buy up one of your competitors, or we might come to you and make you a take it or leave it offer and try to buy you up. But basically, to sell, because we're so big, you're going to have to use our platform. Let us collect your data to know how you're charging and things like that. And then we're going to use it against you to try to compete against you. And this is the kind of thing that this price thing can't detect, right? If all you're looking at is price, you can't see how inherently egregiously abusive this is, right?
Like all this shady stuff that's happening on the back end, sure, it doesn't hurt consumers, but that's the whole point of the structural argument, is that if this is allowed to continue happening, things are going to get really, really bad.
Yeah, and so this is more of an example. Like, this is just one egregious example, and you'll find tons of examples in the literature of being able to tell stories and explain the nasty things these tech giants are doing. I'm not saying run this exact one, but be able to tell stories like this of they're making them basically use their own data against themselves, right? Another related one I think is good. This is a more broad argument. This comes from The Economist.
It goes into the general idea of like companies are so powerful they can strong arm competitors.
Yes, they have the power to strong arm and kill innovation. What this basically says is tech giants target and kill or acquire potential competitors, which hurts business innovation. And the basic idea is If you're a startup and you're plugging along with some, something in an area of big tech, something to do with the internet, something to do with technology, they're watching you. Google's watching you, Facebook's watching you, Amazon's watching you if you're in their space. And what typically happens is if you've got a good idea, what they're going to do is they might come to you and offer to buy you out. But the thing is, they're not really going to negotiate with you because they know that they can just copy you.
A good example of this is like app developers. For instance, Apple, they know if you want to develop an app, you're going to have to put it on their app store. So they're going to make you an offer, say, hey, I really like this app that you're doing. I would really, really, really like to have this app and own the rights to it so we can put it on our store. Otherwise, we're not going to let you sell it on our app and you're not going to make any money.
Or more ominously, and probably even more commonly, we'll just make our own.
Yeah.
Right? We've seen what you're doing. We have billions of dollars in capital, and we'll either buy you out. And look, hey, you'll be a millionaire, and that's good.
I mean, that's a dream for a lot of app developers.
Yeah,
is to make an app and sell out.
I got $5 million. Jeff Bezos has $100 billion, right? You're never going to see that. These companies are never going to grow to be competitors, right? We're going to kill them in the cradle. Maybe not kill them, but draft them into our company. And then if you don't agree with that, and that's what this Economist article talks about, so read the Economist article. If you don't agree to sell to us, fine. We have billions of dollars. We'll just make our own version and you'll get nothing. So we'll either buy up our competitors to keep them from competing with us, or we'll kill them and make what they have. And the analogy I used, I was telling Josh earlier, is it's kind of like the Matrix. If you've watched the Matrix, the machines do one of two things. They either use you as like energy, like as a battery in one of these pods, and if you don't like that, then they just kill you. And so effectively, these big tech companies are just like the robots in the Matrix. They're either, if you're a startup, they're either going to harvest you and use you, or if you don't agree to that and try to break out of it, then they're just going to kill you off. And again, being able to tell these types of stories, right? The next argument, and this is one I think is an important sort of preemptive rebuttal, but also a strong statistical argument. Tech giants arguably are lowering wages. This comes from CNBC. The basic argument it makes is that, since 1997, and that's, by the way, a long time. That's like pre-tech boom, right? Workers in the tech industry in Silicon Valley are actually seeing their wages go down on average. Everybody but the richest, right? Everyone with the most well-paid. And the argument, the great thing about this article is it links to antitrust because the reason that it's happening, according to these experts that it cites, is when you have these giant companies that sort of dominate the market, they only need one of you, right? In other words, they don't need as many very specialized software engineers, which means that they're more efficient, yes, right? But that means you have a job and a skill set that could command $200,000 a year, huge amounts of money. And in a competitive, healthy market, there might be 20 companies that want to hire people like you. Instead, there's just one. Now, it's a big one, right? They might need to hire several, right? But they're not nearly as much demand for these high-skilled jobs. And what ends up, and also these companies go out and do a lot of, for example, hiring of temp workers and contract workers, contract laborers. But what they end up doing is driving the wages down. So there's this myth that we're having all these people get rich out in Silicon Valley, but what these statistics show is that because they're so big and so powerful and so streamlined, you actually end up seeing people making less as a result of these massive companies, right? So that's a concrete one that I kind of like. Another sort of more abstract, and this again from The Nation, is these tech giants arguably threaten democracy. And this is an argument that, again, just goes straight to the idea of if you're looking at prices, you're not getting the full picture. These companies, and the Nation article, it doesn't really fully sum it up in this snippet here that we put here, but basically...
It's important to understand the idea.
Yeah, the basic idea is that they funnel, first of all, number one, and this is really maybe more about wealth redistribution or power distribution, but you're funneling so much money into the hands of already extremely wealthy people, the Jeff Bezoses and the Mark Zuckerbergs of the world, right? Instead of smaller, innovative startups. And wealth concentration, you can go out and find cards about how, wealth concentration is a bad thing and how wealth distribution is a better thing. When too many people are too rich, that's a problem. But in addition to that, the other thing it talks about is how these companies are becoming part of our infrastructure, just like our roads and our railroads and our airports are part of our infrastructure. So too is Facebook and Google and Amazon becoming kind of part of the background of what it means to operate in the world and in the United States.
It's pretty hard to avoid these companies in an everyday life living in America.
And can you imagine if like a private company owned all the roads, and even if they were behaving nicely, we would be very troubled by a company that owned all the roads or owned all the sea lanes or things like that. We wouldn't tolerate it. We think these things should be public resources. And for a private company with private profit motives to have control over it is in itself problematic, even if they're not raising prices, is sort of the argument, right? Here's one that, as a Mississippian, it sort of struck me. Tech giants exacerbate geographic inequality. Most of these companies have the overwhelming bulk of their jobs in coastal cities that are high income. The San Francisco Bay Area, Seattle, places in California. I think Amazon recently, it was...
Not Starkville, Mississippi.
Not Starkville, Mississippi. If any of you, I mean, as much as we're trashing you, if any of you want to come here, I think it would be useful for us. But, not really anywhere in this region of the country, right? I mean, Amazon just advertised that it was going to have this big new headquarters, and it was going to start just sort of distributing the benefits of its wealth somewhere else in the country outside of just these coastal cities. And where did it choose?
I mean, the closest we would have gotten is like, I guess, Georgia.
But what it actually chose, what it actually chose was New York and Northern Virginia, right by D.C. I mean, come on, guys. This what it does, and the impacts of this, according to the Nation article, and there are others, is it does two things. It drives up the cost of living and leads to massive wealth inequality in the cities where they go. Remember the housing topic we did a few months back. It helps contribute to that. That's why housing is so ridiculous in San Francisco and Seattle and places like that, because you've got tech companies with ridiculous salaries and other people can't compete. But it hollows out the middle of the country and the country places where you don't have these companies operating. Whereas it used to be, there were 1,000 little discount store chains across the country where people could make a good living and start a franchise of one of these stores and have a good life. These things are fleeing to these massive coastal centers, and it's hollowing out, and it's leading to a country that is vast inequalities in terms of wealth, and that's a bad thing, right? Another thing to consider is the idea that tech giants can control public discourse. Again, it doesn't matter what the prices they're charging is. If these companies are so big that they don't have competition, then they effectively become the arbiters of what we can say. This video that you're watching right now is on a platform that is owned by Google, right? Is it Google? It's Google, right?
They're being very generous in allowing us to talk about how bad they are.
Thank you to our corporate overlords for allowing this slanderous video to be posted. But at any rate, if Facebook and Google can essentially decide either overtly or covertly what can become part of the public discourse. They are the tools people often use to communicate with each other, right? They can ban you. They can demonetize you. Like we recently saw, there was a conservative guy, I think named Steven Crowder just today, who got like demonetized by Facebook. I think in his case, arguably deserved it. He said some really nasty homophobic stuff.
But the general idea is if political speech or any sort of speech could be altered, like if they can streamline or control the gates for what you're wanting to watch.
Who should have that power? I mean, we have decided that even the government shouldn't have that power. The First Amendment, we don't want it happening. What happens when the de facto gate to speaking is owned by corporations?
I mean, Google could decide tomorrow that they don't want to have any left-leaning or
right-leaning or whatever, right? Yeah. And the idea is they can do it without even letting you know. I mean, it's one thing to straight up ban somebody or demonetize a YouTube channel, but that Google can very quietly reduce you in the priority of their search algorithm. You might not know it forever, but it can cripple a company. It can cripple a political campaign, things along those lines. Who should have that power? I mean, that is like Thanos level power that nobody should wield, right?
There was an interview with Jack from Twitter and one of his corporate lawyers, I think on the H3 podcast, where they talk about stuff like this, corporate censorship. I imagine probably a couple of you out there that watch H3, go check that video out. I mean, there's a lot of info, especially about places like Twitter and Facebook banning certain groups or like shadow banning, stuff like that. A lot of stuff you've probably seen before. It'd be nice to just have actual like peer-reviewed literature on it rather than YouTubers talking about it.
So what I would suggest is a combination. I think you ought to be able to have some anecdotal examples of the really nasty things that they do, like with Amazon sort of using data against their own customers / competitors. You should have some economic stuff about, for example, wages and things like that. And I also think, that at the end of the day, you ought to have something that says it's not just about money. These companies are so powerful that they control discourse. They become like their own little sort of mini sovereign governments, and that in and of itself is problematic. Our current enforcement philosophy cannot account for that at all. And some mixture of those is, I think, the mixture that the pro is going to want to look for. So have we covered the pro?
Yeah, I think so.
All right, y'all. We will come back in just a second and do what I think is even more fun, which is the con. Okay, so now at long last, let's talk about the con. Initially when I started working on this, I thought, oh boy, con's got a real hard road here, because everybody and their brother is out there talking about how we need to crack down on antitrust enforcement in this area. But I got to tell you, it's just sort of like one of those things where, what the cool kids are all doing may not necessarily be the right thing, particularly in the context of any specific resolution. And I think for both of us, the more that we have looked at this on the con side, the more we've seen they have a real viable argument,
My experience was there's not as much like tangible cards that you're going to find about like, a bunch of big tech companies are really good and we're glad that they own so much market share. It's more so like theory of, well, look at the impacts of what you're actually implying in terms of the pro case and see how, like once we explain how the con cases work, you'll see there's kind of like a lot of really good ideas that come from the con inherently.
We're not here to argue that tech companies are perfect. We're here to argue that the solution proposed by the resolution is not going to necessarily make things better. So like last time, what I want to do is start with kind of 3 strategies that I think you might see, then go on to some sort of preliminaries that you need to know to run an effective con. And then finally, let's just get into arguments. We got a bunch of them, so we'll just go rapid fire. So to start with, how exactly would the con case work? So 3 strategies. The first one is kind of what Josh said we aren't doing so much of, but it is doable, which is antitrust would undo the good that tech giants have done. And this is basically a direct conflict case that says these tech giants have actually done a lot of good in the world, right?
They're not mustache twirling super corporations. They do have some benefits.
They're not the Standard Oil of John D. Rockefeller just saying, let's raise the prices. They are doing a lot of good. Companies like Amazon and Google have honestly made consumers a lot better off. Amazon does lower prices. I mean, there are empirical studies, and we can drop some in the notes, maybe drop some in the slides, about how they do lower prices for consumers. They're not perfect, but their size allows them to negotiate and demand lower prices, right, which eventually are passed along to consumers, and lower shipping and things like that. It also lets these companies undertake massive projects. I mean, look at Google. Google allows us to have things that we could never have imagined when I was a kid for free. Searching all the information in the world, having maps of every street, 3-dimensional maps of every street, free cloud storage. I mean, I've stored my notes for this, video on Google Drive.
It's going to be uploaded on YouTube.
Right, it's going to be uploaded on YouTube.
We don't have to pay to do that. Y'all don't have to pay to watch this.
I mean, it's really hard to argue that these things are making the world worse. And these are things that smaller companies can't even attempt. And the other thing that you would say on this is, and by the way, if they ever do start acting like monopolies and they do start raising prices and behaving badly, well, then we can revisit this topic then, potentially enforce it then. But right now, it's just not harming anybody. Now, the pluses on this is it's a strong intuitive appeal. You can point to tangible benefits. There's also a strong sort of free market theory. You can go back to some of the theories that these free market folks used in the 70s, like Robert Bork, to advocate for the consumer welfare theory, and you can draw upon the theories that they used to say, we shouldn't be in the business of picking the winners and the losers and saying who's too big or who's too successful unless and until we have a very concrete example of how people are being made worse off, and it's just, we don't think that's happening, right?
I mean, even with the structural approach, you could say, look, the fact that Amazon has so much infrastructure in their delivery system, that's providing good for everybody because they can give you free shipping. Well, it's really not that much of a cost to them because they're so big.
The other thing is you have to tell us, if a company is successful in a free market, that means people are buying its service without a gun to their head. Now, don't get me wrong, economists will tell you, of course, there are stories that you can tell about why, free market transactions may not always be socially optimal, but the burden is on the person who wants to regulate to tell a clear story about why all these millions of people who think these services are good and are beneficial and are making them better off, that have made these companies so big. They didn't steal this money. Yeah. They did it through free voluntary transactions. Why are all those people wrong? Or at least why are they all having to do something that's against their interests?
I mean,
right?
We're not talking about it in this case per se, but There's a reason Netflix is worth $200 billion.
Yeah.
They're a really good streaming service, and now Netflix Originals, they're skyrocketing their growth. They're just making a good product.
Right. The minuses on this is that it is a narrower or more vague pro case might be able to sidestep this. They might be able to say, oh, don't worry, we're not going to do that kind of antitrust. We're not going to undo any of the stuff that you're worried about. It's just going to be a little nip and a little tuck there. So they could try to sidestep it. And also, like many con cases, it's going to need strong blocks for the antitrust enforcement is the status quo. You're going to have to win that, because if you lose that, then you lose the round on this strategy, right? Strategy 2 is tech. This is my favorite. I'll just tell you. Tech giants have flaws, but antitrust is not the solution. And basically, this one, I love it because it basically says, look, we're not here to defend antitrust companies. Tech companies, giant tech companies. Antitrust litigation and prosecution requires this incredibly complex analysis of consumer harms, projecting future events. It requires that we link our regulation of these companies to some showing that they are anti-competitive. That's hard to do. It's hit or miss. Litigation in antitrust is notoriously hard to win. Yeah. Sometimes we will lose. So, and in many cases, these century-old laws, and remember, you're going to say we have to advocate for the existing laws. Fair enough. These laws are a century old, right? They often don't fit well with the problems that we're seeing today. So you can very well lose. So here's my proposal. Why should we use antitrust? Antitrust is this crude old tool that doesn't do a good job of addressing these problems. If we want to regulate these companies, let's just regulate them. And this is what's called sort of the common carrier theory. And Lena Khan, who's the big advocate of antitrust, actually in her piece specifically says that common carrier style regulation would be another good alternative potentially for regulating these tech companies. And the basic idea is, look, if you think that Facebook needs to not sell data, you don't need to have an antitrust lawsuit or try to make some link to why it's too big, because, by the way, small companies sell data too, right? You just need to pass a law that says, Facebook, you can't sell data.
I mean, think about every little like rinky-dinky app that you've downloaded that says, can we access the microphone, your contacts, every other bit of data on your phone? And you say, yeah, sure, why not? Or every time you click agree to terms of service, they're doing the exact same thing. Right. They're just not Facebook.
Yeah, I mean, exactly. And if you want Amazon to not use the data of its third-party sellers to compete against them in their own markets, pass a law that says that. But you don't need to use the antitrust theory where you have to show that they're too big or they're raising prices. It's like trying to fit a square peg into a round hole. So the argument is basically you sidestep every piece of offense to the pro use and say, okay, fair enough. We agree there's lots of problems with these companies, but antitrust is an awkward fit. It's an old-fashioned law that's often hard to prove. It's hard to show that what's too big, what's anti-competitive. Just pass whatever laws you... And by the way, pro, you have to use the ones we have. Yeah. You can't even revise it. You can't even draft new, better antitrust laws because we're talking about enforcing existing regulations. What we should just do is pass some new laws that say, here's what you can do, Facebook, and here's what you can't, right?
I mean, they better address the problem. It's a lot easier for the con to do it because it sidesteps the pro. I mean, I think that's definitely the most solid strategy.
The pluses are it flanks almost all pro impacts. It does find, it's got good support in the literature. There are a lot of people who think that regulation is a better option, or at least a good option. And it also lets us take the wait and see if they cause actual harm approach. In other words, it lets you sort of co-opt this approach of like, well, you know, instead of having to go out and sort of proactively say, you're too big, we're worried that you might do something bad one day.
And hopefully one day we can prove that there might be a link that you're going to be harming people in the future.
Right, yeah, we think you might be so big that you might one day do something bad, and therefore we're going to break you up now. Why don't we just say, here's what you're doing bad, stop. Right? Isn't that a lot simpler? And we'll put some links, but you'll need to read up on the idea of common carrier regulation. Common carriers, for example, are things like the telephone company, things like public utilities, like the electric company. We have a strong precedent in this country of imposing regulations on these companies that effectively act as sort of quasi-public entities providing infrastructure. We tell, for example, the electric company what rates they can charge. We tell cable companies in many cases cases where they have to provide service. So why not use that same model of regulation on these companies like Google that have become the de facto, search engine for the world, and just say, if you're this big and you're a search engine, here's the things you got to do.
And it's really simple. I mean, not so much anymore, but back in the past in Mississippi, Comcast was pretty much the only way you're going to get internet or cable down here. So they were just like, yeah, you can't charge exorbitantly high prices for the cable or internet packages you're providing. We're just going to set a cap on it, call it a day. And it worked.
It turns a debate from should we do something to a debate about what should we do.
Yeah.
Right? And the downsides are, again, you got to have strong arguments for the antitrust equals the status quo, because you have to say basically that, we're not going to do both and we're not going to continue with what we're doing now, right? Because if we continue with what we have now and it already is enforcement, then you're basically, it's a sort of perm do both or do both at the same time argument. So you have to win that. You have to show the status quo is not enforcement, but you say, well, we don't really need enforcement. We need something else. The other thing is, someone could say you're running a counter plan. The argument would be, this is no more a counter plan than do antitrust is a plan. We're not even saying what regulations you should have. We're just saying you should regulate them using the common carrier theory. That is not a plan. That is a super vague common sense solution of exactly the same level of vagueness as do antitrust, right? So that's number 2. I like it a lot. It requires a little bit of wrapping your brain around, but it's simple and it's elegant. Could it be a little complex for some judges? Maybe, which is why it would require a simple explanation at the beginning. Judge, we're not saying these are good companies. We're saying that, so-and-so. The last one, I have a squirrel next to it because it is a squirrely argument, but basically it's the inverse of the status quo case on the app. And basically what you say here is we're going to argue that the status quo is non-enforcement, that enforcement is not happening now, but that we are currently engaged in investigations and studies and reviews with these expert committees, right? In other words, DOJ, FTC, and Congress are all investigating this issue. And within a matter of a few months, they will tell us, number 1, whether antitrust laws should apply, and number 2, whether it's the ones that exist now that we should enforce, or alternatively, whether it's new ones we need to pass. So we don't need to do any, you have to vote now, Judge. Yeah. And if you vote to enforce them now, you're jumping the gun. You should wait and see what these various investigations from 2 federal agencies and Congress uncover, right? And in a few months, and I get it, it's kind of disingenuous, right? But in a few months, they might say, give them time to operate. They might say we need to enforce antitrust. They might say we need to have new antitrust, which is not topical and doesn't affirm, or they might say we don't need to do anything, but don't jump the gun. There's nothing so urgent that we need to do it now, and we can't wait to get the facts right. Is this squirrely? Yes, but it's not crazy.
And it doesn't take that long to explain either.
Right.
Throw it in on the end of a case, and your opponent could spend a really long time talking about it or ask you a bunch about it in Crossfire, and you've got the meat of your case in strategy 1 or 2
and
they ignore.
It's not based on some Looney Tunes debate theory kind of thing. It's based on, look at what's happened over the last 6 months. Yeah. This is what's happening in the real world right now.
6 months ago, if you had this resolution, it would be an entirely different debate because we didn't have all these investigations going on.
But we say a lot, and we've said this in videos before, sometimes you can out-current your opponent. You can look at what the latest developments are. We talked about this on some of the videos, international relations related videos earlier. But you can basically say, look, there is a widespread, ongoing, fact-finding mission by all branches of government going on. If you vote to decide whether we need to do this or maybe something else, if you do it now, you have basically jumped the gun and invalidated all those smart people with degrees from big universities and huge amounts of experience. Just let them do their job. And maybe in 6 months' time, we'll know the answer to this, but don't jump the gun. And, lay judges may buy that. I don't think it's a crazy argument. Anyway, a couple of quick things I think we need to talk about from just general things that the con needs to be able to do. First of all, you're going to have to win the argument that enforcement is not the status quo. So number one, you're going to want to read empirical evidence, and we will drop some of this in the notes where people saying, and I'll show you some in just a second, about why, consumer welfare doesn't mean enforcement. It's just not being enforced. We'll talk about that. But also, I do think you need to have some fairness-based arguments. We might call these debate theory arguments in other spheres. I would just call them fairness-based arguments. A block, some cards about how if the pro can win simply by saying, let's not give this industry a pass let's not make it the one and only industry that gets a pass. Let's not shut down these investigations. If that's all the pro has to do to win, we can't win.
And I mean, it's the exact same thing as, like, we were talking about this earlier. If the code of regulation says they have to meet certain deadlines and the pro's like, oh, well, yeah, of course that's a good idea.
Yeah.
Clearly that's not what we're talking about, and it's not fair.
Basically, yes, it's totally unfair to say that the pro can win simply by saying we should not exempt giant tech firms from these laws that apply to everyone.
No one's saying that.
And so two reasons why, and you see them here. Number one, PF is supposed to focus on current real-world issues. As you say, no one in the world is debating exempting, like, Microsoft. If Microsoft goes out and buys up all the other software companies, of course that's going to be reviewed by the FTC. Literally no serious adult in the world is suggesting otherwise. So a debate about whether we should just, like, remove them from the ambit of all antitrust is not a real world debate, which is what PF is supposed to be. And secondly, it's totally unfair. There's no ground. Basically, if we're going to go with this, then the national championship becomes a contest to see who can flip pro the most times in a row.
Yeah.
Right. And we don't want that. Right. There's just no ground at all. So you've got to have both the evidence and also the fairness and education type arguments. Now, in terms of winning the empirical arguments, Lena Khan has a great explanation of why we are not enforcing in the status quo and why the Supreme Court and federal agencies have basically adopted this view. So you can use her as sort of your card to help explain that. And there are others as well. A more recent one, again, from that Great Nation article that we talked about, is they basically give a current explanation of how since the 1970s, the phrase, I like this quote here, by the time Bezos set up his book-selling operation on the internet, however, antitrust laws were no longer being enforced in accordance with their original purpose. So this is a good common sense way of saying all the experts are saying these laws are not enforced in the status quo, right? Last thing before we get to the arguments, and there are a lot of them, is as the con, you are going to need to be able to push back on these sort of vague, loosey-goosey pro ideas that these firms are too big and they have too much power. That they're going to keep saying things like that if you don't hit back on them, and you've got to make them say exactly what they mean. So if they keep saying these firms are too big and have too much power, you have to push back. Why do they have too much power? What is so bad about them having power? They're big, successful companies. Tell me exactly what they're doing wrong. Being big is not necessarily the worst thing in the world. Some of the happiest people in the world, for example, come from countries that have big, all-encompassing governments. What is necessarily wrong with being big and influential? You have to tell me. Aren't there other search engines? Aren't there other online retailers? Aren't there other social media platforms?
It's just as easy for you to go to Bing instead of Google, but you don't.
If Google was so bad, wouldn't Bing be raking people in by being better? I mean, what's right?
That's the whole point of free market capitalism, is that if someone's so bad, another competitor is supposed to come in and not be that bad.
Antitrust doesn't mean the market is split up 50-50 or 25-25-25. As long as there's another competitor that can do the job, the theory goes, right? As long as there's somebody out there, if you were doing a terrible job, that they could offer a less bad job, in theory, they should be able to capture the people who are unhappy with you. Bing exists, right? Other social media platforms exist. There certainly are people who compete with Apple in the tablet and smartphone markets, obviously. There's tons of them. And by the way, doesn't Google offer dozens of incredible products for free? You need to push back if they just say they're too big, they're too big. What exactly are they too big to do correctly, to do right? Why are they so big? And then the second thing is, why is the problem that these companies are too big? If they keep saying, well, Google does, like for example, if they say that Facebook harvests your data, your response would be, we have this great article here that comes from The Atlantic that we'll link to. Tons of these little skeezy apps that come from companies that are running like an office the size of this room, right? Harvest your data and do shady stuff with it, obviously, right? It doesn't take a Facebook or a Google to harvest your data. And so one thing you've got to scrutinize is, why is it that the problem that these companies are too big? Because that is what antitrust law is designed to fix. right? And this kind of goes well with the idea that maybe a solution is to regulate as opposed to just trying to link it to them being too big, because many of these problems are only sort of loosely or tangentially related to their size, right?
Yeah, right. I mean, if, for instance, Google or Facebook, the only real issue is with them harvesting and selling your data, rather than busting up that whole entire corporation, just say,
tell them
don't hoard data.
Yeah, just tell them they can't.
It's that simple.
Or at least here's what you can do. I mean, they have to make some money, but like here are the limits on what you can do with it, right? And then the last thing I think you need to do is to point out the elephant in the room. It's very easy for the pro to stand up here and trash corporations. We all love doing that. It's super fun.
There's too much wealth at the very top of the 1%.
Yeah, dude, the Bernie Sanders too much wealth. Yeah, we're gonna get Bernie Sanders going in there. But this isn't a debate about whether corporations are good or whether these companies are good or perfect. It's a debate about whether we will solve these problems best, right, by breaking them up or by shrinking them, and whether the problem is their size. And it is the job of the pro to explain exactly why the problem is that they are so big. And if they can't do that, they can't win. And you need to keep pushing back on that, right? Okay, let's just start arguments. We're going to start with some of the weaker ones and go to some of the stronger ones. The first one is tech giants raise wages. Some people may be tempted to run this. Amazon obviously raised its minimum wage to $15, which is kind of the benchmark for like living wage. The problem with that is, number one, the evidence we looked at earlier, which shows that they're actually these giant companies are lowering, wages on balance. And number two, there are arguments about how they really just sort of did this to shaft other companies, right? And how it may not ultimately make its way out. And
no one wants to go work for another retailer if Amazon's paying them $15 an hour.
Yeah, basically. But it's not bad. I mean, I'm not saying you can't use it, but you just need to be aware that there is evidence on the other side that says on balance they actually lower wages.
If you're doing bullet points, throw it in there.
Yeah. If you want to do a one sentence, like according to so-and-so, they raise wages, if you can get that, fine.
Or if on the pro they say, well, Amazon is lowering wages, just have it ready to be like, well, no, they're not. They're paying people way more than they would be getting paid at like Walmart. Actually, that's not true. Walmart pays pretty well. But anyways, right.
But there are other arguments about why Amazon is, and this is my pun for the day, amazing. Okay, never mind. For the U.S. economy, for example, there are statistics that suggest that Amazon, by being a distributor of very low cost, is actually really good for small businesses. It helps grow small businesses. We'll talk about that in just one second. That even though they're lowering the number of retail jobs in stores, that when you add their numbers to the remaining numbers in stores, the total number of jobs is actually increasing thanks to Amazon. So there are arguments that it's actually beneficial overall. There's also the argument on the economic front that Amazon, and this is true, Amazon lowers consumer prices. Now, you may say that's not the only thing that we should be looking at, but it is a big thing we should be looking at, right? Amazon basically serves as this massive, powerful negotiator to get, for example, the best deals on shipping, and to get lots of products in the same place. It gives you incredibly powerful tools, for example, to look at reviews of products before you buy them. I can think of a dozen things I've bought over the years that I didn't really know anything about. Like I bought a wet vac for my carpet. I would never have known what constitutes a good wet vac versus a bad one, but I went on Amazon and got the aggregated wisdom of thousands of people on this. Right?
And it makes sense. Like Amazon's getting a cut of all of these sales if it's on their platform. They're gonna want to sell as much as they possibly can, and that's gonna help the third parties that they're working with.
So they're lowering prices. They're providing consumers with information. There is no question that they are providing tangible benefits to consumers. You can make a similar argument for Google, giving people tools for free. They do help consumers, right? And then Amazon itself will tell you that empirically, this argument that they are shafting their third-party sellers and really harming them is not true. We'll put this in the links, but Business Insider 2019 says Amazon has reported, look at our sales data. And he basically says, these third-party companies are coming in, according to Jeff Bezos, and, quote, kicking our butt, Amazon says. In other words, yes, we're growing, right? We're selling more of our own products and we're selling more of our own services and things like that. But their growth, third-party sellers on the Amazon platform, their growth is faster than products Amazon itself is selling.
More than doubled.
Yeah, 52% year-over-year growth, which is just
like that's not insignificant.
Bonkers. That's bonkers. But 25% is great too. That's what Amazon is doing. But 52% is what the third-party sales are doing. Assuming you believe Amazon's numbers, which I don't think they would directly.
I don't think they put it out if it
wasn't just
true.
False. Yeah. But it is from them, so you have to be aware of that. But the idea is like this idea that we're harming people who sell on our platform. Not only are we helping consumers, we're actually helping them. Their sales are going up dramatically. So what's the problem here, they would say, right? Tech giants are easier to control than small firms. Josh found this, and I thought it was really, really good. The basic idea is that tech companies are really big and they have very public, people know who the CEO of Amazon is and CEO of Google. And if they're behaving badly, you can do what they did with Mark Zuckerberg, which is call him right in front of Congress and make him sit there and make a meme out of himself, and testify. And in that way, right, the argument is they're easier to control. And the argument that the New York Times here, Farhad Manjoo, says is consider the Russian propaganda thing. If you had 500, tech companies doing social media, it would be much harder to effectively respond than if you basically have one behemoth and you can look and say, look, we're going to name and shame you very publicly until you comply. And they did comply, right?
Well, and also kind of like, Amazon, I'm sure y'all saw the stories about them treating their workers very poorly. If that blows, there's definitely other retailers who treat workers poorly, but the fact that Amazon has such a big public perception, hopefully that would incentivize them to change it so that they don't get that kind of negative press.
One thing is they can't hide behind sort of this is what the market demands. Like if it's 500 companies competing, you can say, well, we would love to do better, but all of our competitors pay their employees crap, so we have to do the same or we'll go out of business. Amazon, you're raking in huge amounts of money.
They don't have any excuses.
You have no excuse, and that is part of the reason why they raised their minimum wage to $15 an hour. Right?
We'll treat you like crap, but we'll pay you well for it.
A related argument from the same source is this: what I call better the devil you know. And the argument is, look, these decisions about antitrust don't happen in a vacuum.
Yeah.
There are other companies out there like Alibaba, which is a retailer from China, Tencent, which is a software company from China, that if we go and we crack down on our tech companies and tell them they can't be too big, the rest of the world isn't going to just shrug its shoulders. And I think Senator Warner, I believe, I'll drop that in the notes. He basically said he thinks this is what's going to happen in addition to this New York Times article. There are sources on it, but the basic idea is if we go and crack down on our tech giants and say you can't be big, you can't be powerful, well then the Alibabas of the world and the Tencents of the world and these Chinese firms and other firms are going to step in and they're going to try to be the hegemon. And as bad as you think maybe having a giant Google or a giant Amazon having influence over it would be, how much worse would it be if every single Google search ran through some dominant Chinese firm?
At least these are American companies and we can control them.
And that's not meant to be jingoistic and to say American companies are the best. It's just that we are a country that has the rule of law, right? We have, these are fairly progressive companies. These are companies that take pretty good, not perfect, but pretty good views on equal rights and human rights issues. Wouldn't we rather have them be, if the market is set up in such a way that it is easy for one company to become dominant, wouldn't we rather our companies that basically share our values become dominant rather than create a vacuum for the Alibabas of the world to swoop in and not share our values, right?
And the thing is, kind of like you said earlier, nothing's happening in a vacuum, right? International agencies, different countries all see the impact that things like Google, Facebook, all these different corporations have on their own economies.
Right.
They probably don't like the fact that all of these are American, and we should love the fact that they're American because at least they're not German, at least they're not Chinese, at least they're not Russian, that have such a huge impact on our culture. And we need to try to keep that as much as we can if we can manage it.
I would say, because Chinese companies like Alibaba have to have a Chinese Communist Party committee in their company, to keep tabs on them and tell them, what they can and can't do. If I were the Chinese government and I knew that the United States were essentially tearing apart Google, the first thing I would do,
invest
is I would go pour every resource I could into a search engine, and if it were Amazon, I would do it with Alibaba in order to gain that dominant status in the world.
And the thing is, this kind of goes back to what we were talking about with political censorship. Yesterday was the massacre, or was the anniversary of the Tiananmen Square massacre, which a lot of memes are saying, yesterday in history in 1989, nothing happened. Because according to Chinese search engines, nothing happened yesterday in 1989.
Right.
If Google doesn't exist and China has a lot more influence on the search engines that we're using, stuff like that is going to become a lot more prominent. And so even though they're bad, at least, or really big, not necessarily bad, at least they're big and American.
Right. Exactly.
And they hold the same values.
And we can go and tell them, if we really don't like something they're doing, we can tell them to stop.
Yeah.
Which we can't do.
If they're in China.
Yeah, exactly. So another one is breaking up the giants won't solve the problem. This comes from an article from Robert D. Atkinson. The basic argument here is like, if you're going to implement an antitrust solution, you can't fiat the particular solution, right? Because we can't run plans. So you kind of have to just basically expect that whatever the most commonly discussed things out there in the real world will be the things that happen. And the most commonly discussed things are, let's tear these companies apart into separate parts. But what Atkinson says is like, even if you tore them apart in certain ways, the things you were left with would still be incredibly powerful. Like if you split Amazon's web services from its retail, you would still have this incredibly powerful pair of companies. So the antitrust solution of let's tear them apart, as opposed to this, by the way, dovetails nicely with the let's regulate them, let's not break them up argument, right? Breaking them up may not do anything good. So
breaking up Google into a search engine and then a separate cloud computing company, they're just going to be a really powerful search engine and a really dominant cloud computing company.
And maybe slightly less efficient, but still better for consumers.
Realistically, that's just going to harm the consumer.
Right.
They're going to take that like loss in revenue or loss in efficiency and say, well, you know what? Maybe we will start charging you.
Yeah, maybe. I mean, but yes, definitely. So, Josh, you had this one. Why don't you explain it?
So pretty much the idea on whenever we're looking at this term in the resolution of tech giants need to have some sort of regulations enforced on them, what we're saying is that, okay, clearly we have some sort of problem with these companies, but it's not saying what exactly the problem is. And a lot of times when we're talking about tech companies, the issue isn't just that, Google has a lot of search results or a lot of people use Google. The problem is that Google is collecting data. And a lot of these big tech companies have the capacity to collect and hoard and then sell data. So if the biggest issue with tech companies is that they're collecting and hoarding and selling data, this kind of goes back to the
very first slide.
Making laws. Just tell them they can't do that anymore. Congratulations, you've solved the issue. I mean, the fact is, there's a lot of other much larger monopolies that exist. Why aren't we focusing on them, right? If a lot of different corporations have, huge market shares, they've got giant market caps, and they're doing the exact same thing, but they're not collecting data, that's probably the reason we haven't really seen them come up that much, because it doesn't really matter. Well, they're making a good product, and we're fine with it, and they're not collecting our data.
And this kind of goes also back to that very first slide we had at the beginning of the analysis section about how even if you just look at the top 10 market cap companies, some of them are doing stuff that has nothing to do with our concerns.
They're entirely back end.
In other words, tech giants is too broad a target. You're painting with too broad a brush. Maybe we could approve a resolution that says we should do this with Amazon and maybe with Google. But, you've got 3 of the top 10 companies in the world in terms of market cap that are basically just selling standard products. And nobody thinks that they're doing anything wrong. So the argument would be that, trying to find some novel tech enforcement for these companies would just be too broad a target. We should focus on data as opposed to focusing on let's go out and attack everybody that's a tech company over a certain market cap. Not every tech company over a certain market cap is doing anything worth our time.
Yeah, right? Why do we care that Cisco is doing whatever they're doing? They're making chips.
Are there other, or is Intel's making chips, Cisco's making networks? Are there other companies doing that? Yes. Can they compete? Yes. We're done here, right? Why do we care?
We need to start busting them up because they're just too big. That doesn't make any sense.
Yeah, there's no unique consideration that warrants that. So tech giants is too broad a term would be an argument. Yeah. Another one from Robert Atkinson is these tech companies take risky bets on game-changing projects that others can't afford. So, for example, Google does these projects all the time from SpaceX to countless, services like mapping the entire world, and numerous other services that and Google will tell you we can afford to spend $20 billion on something
just for fun.
We don't even know if it'll work. But these companies have massive budgets and often either sell these things at very low cost or give them away for free. They're investing huge amounts of money that other companies can't invest. Small companies that are startups or even medium-sized companies cannot spend $20 billion trying to see if we can help mankind go to the moon. Yeah. They just can't.
I mean, that's the whole benefit of things like SpaceX. The only real competition SpaceX has is with NASA, the federal government, right? If they're willing to just dump money into trying to explore Mars, that's great. I mean, the fact that they have a big market share isn't really an issue.
Yeah.
They're the only ones really in the market, and we let them do it because I personally think it's because we're not selling their data or they're not collecting data.
Right.
But the fact is, just because they're a big part of it isn't really a problem. They have the money to blow on research. why not let them?
And they're not blowing it. I mean, they're using it effectively. Google also, a former person I knew in high school who was a debater here in Mississippi works for Google on self-driving cars. Google hasn't made a dime on self-driving cars yet, I'm pretty sure.
I mean, half the research we do here is never going to turn any sort of profit. We do it because that's just how research works.
They do the same thing we do here at Mississippi State as a university. We do it with public funds, your tax dollars.
I mean, I can tell you right now, the research I do, it will never make $1.
Right.
We do it because they want us to.
But they do it, we do it with your tax dollars. They do it with their own profits, right? So anyway, that's another argument.
We should break up the universities.
That may be the next resolution, right? Tech giants make technology more affordable. Again, Google makes stuff for free. When Facebook acquired WhatsApp, one of the things people say is, we should reverse this Facebook acquiring WhatsApp. Well, here's the news flash. Before Facebook acquired WhatsApp, you had to pay for it. Yeah. It was a cheaper text messaging option.
That's why a lot of European countries use WhatsApp, because it's cheaper than text, but it wasn't free.
Now, we may be worried about some long-term question of market share and whether they harm somebody in the long run, but the simple fact of the matter is that merger resulted in something that helps lower-income people go from you've got to pay for it to it's free. Right, and this happens again and again. Amazon lowering costs again. These things are tangible benefits, and so again, if antitrust is this blunt instrument where we've got to break them up so they can't do these things, why don't we just regulate them? Why don't we just say, here are a few things we don't want you to do, but we got no problem with you go buying up companies that charge money and making them free, right? There's nothing wrong with that at all.
Those evil corporations paying their own money to give you free stuff.
Yeah, and this is because, this is my note down here, but small companies need to make a profit off their stuff right now. Facebook, Google, these companies can just make it a side project that doesn't generate any money for them. Regulation, non-antitrust is the answer. Now, this goes back to the earlier argument, and this is just a nice little conversation with a guy named Barry Lynn from Open Markets, and he kind of, and I will put the links to this and a couple of other articles, but he basically explains that these problems are not, the basic problem is not they're too big. The basic problem is they have certain business practices that we'd like to see them stop. It doesn't require that they be shrunk to a certain size in order to do it. Let's just pass regulatory common carrier laws. Now, to be fair, Barry Lynn also does think that antitrust could be an option, so I don't want to mischaracterize him, so you may want to cite a different source, but for understanding it, he's a really good option, right? But the basic idea is, he's just saying more in support of the idea that size isn't the issue. The issue is what they're doing, right? And then lastly, the wait and see, right? The argument being that antitrust is basically something where we have to say, we have to act now, in other words, especially on a debate resolution. The implication is you have to act at some point in the reasonably near future, right? And so what we kind of have to do then is we have to guess, and we have to say we think at some point Amazon might in the future start using its market power to hurt consumers. We're not exactly sure when or how. Well, if you would take a regulatory approach, then what we say is, look, if they ever do that, we'll tell them they can't.
We'll cross that bridge when we get to it.
We'll regulate their prices. And the great thing about debate world is you have the judge has a certain degree of fiat power to say, yes, I would do that. I know in the real world it's kind of hard to regulate, but it's also hard to make antitrust laws in the real world. So the idea is, why should we right now try to make some loosey-goosey judgment call about whether they're too big? Why not just wait and see if they ever actually do something to hurt consumers? And then we can either do antitrust then, if it ever happens, or we could use a regulatory approach and never do antitrust. But there's no reason right now to jump the gun when they're just not tangibly harming anybody at this point, right? And so that's what I've got for the con. Anything else?
No, I think that's it. I think the big things, just to kind of recap, first of all, I do think, say, making laws rather than broad scale hitting people over the head with regulations or enforcing regulations, that's probably going to be the best thing. Just make specific laws. It's a lot easier. It doesn't harm non-harmful companies like Cisco that have nothing to do with resolution.
Right.
It's typically, this is the one case where being a little bit more specific and being a little bit more narrow in your solution is probably better.
Yeah.
Just because, there's a lot of what these companies are doing, I don't think is necessarily what we're targeting or what we're against. It's just very minute things that are having a really big impact.
All right. So with that, I tell you what, we will come back in just a second with some final thoughts. Okay, really quick final thoughts. We've gone on for a long time. We do not apologize for that. This was an in-depth topic. It is nationals. It's worth spending a little time on. Thanks very much for your patience. Again, just go in ready to adapt to a lot of different kinds of judges. Know what your theory is. Be ready, and understand your position, for example, on the status quo question. Have good, solid, strong blocks, as many as you can. Read all you can. Immerse yourself as much as you can. And you'll have a great experience. There's a lot of success to be had in NSDA Nationals, and you can absolutely do it.
Yeah.
So,
I mean, my general idea is kind of the same thing I think I say in most of these videos is do kind of how Brett tells us to do in IPDA. Make a story, stick with it, and make it simple. This is a pretty complex topic, but as long as you know exactly what you're trying to do with your case and you know how to kind of condense that down and make it simple, you're going to be doing a lot better than trying to do really deep, complex, legal and economic theory, because 1, you just won't have time to do it. 2, there's a good chance you just get it wrong.
Yeah.
3, the judge doesn't understand or doesn't care, and they're going to mark you off for it.
Yeah. So, with that, hey, if you happen to get in the finals and you're doing those 9-minute thank yous to everybody, throw in a Hail State, and we will send you a free Mississippi State t-shirt. Otherwise, remember, even at Nationals, debate is supposed to be fun. It's supposed to be educational. Congrats on a great year, obviously, if you're going. And so remember, work hard, have fun.
We'll see you next year.
And Hail State.